Hi everyone, welcome to Case Pool. Our case for today is Domestic Petroleum Retailer Corporation versus Manila International Airport Authority. The facts of the case are the following. In 1998, Domestic Petroleum Retailer Corporation, DPRC for short, and Manila International Airport Authority, MIAA for short, entered into a contract of lease of a parcel of land and building located at Domestic Road, Pasay City. A provision in their lease contract provides that an administrative order must be issued by MIAA, and DPRC should be notified of the said increase in rental and other charges 30 days before their imposition. DPRC faithfully complied with its obligation to pay monthly rentals since the start of the lease contract. After a while, MIAA issued a resolution increasing the rent of its concessionaires and lessees. DPRC protested the increase and did not want to pay the increased rentals because there was no prior notice and hearing. However, under protest, DPRC still signified its intention to comply in good faith with the terms and conditions of the lease contract by paying the balance incurred because of the new rates. In 2004, the resolution which increased the rent was nullified by the court for failure to observe the notice and hearing requirements for fixing rates required by the administrative code. Due to the nullification of the resolution, DPRC advised MIAA that it would stop paying the increased rental rate and instead it would pay the original rental rate. Notwithstanding, in 2006, MIAA demanded payment of 645,000 pesos representing the balance from the new rates. In reply to MIAA's demand, DPRC alleged that it could no longer collect on the basis of the nullified resolution and demanded that the refund of 9.5 million representing its overpayment. MIAA ignored DPRC's demand. Before the regional trial court, DPRC filed a complaint for collection of sums of money worth 9.5 million against MIAA, which was granted. On appeal, the Court of Appeals affirmed the RTC decision but modified the same, stating that DPRC could only collect 3.8 million pesos because it lost its right to recover overpayments from 1998 to 2002. Court of Appeals ruled that the basis of DPRC's cause of action is quasi-contract of solutio indebiti, which prescribes in 6 years. Court of Appeals further rules that the prescriptive period is reckoned from DPRC's first overpayment. Since DPRC only filed the complaint in 2008, it can no longer recover overpayments made from 1998 to 2002 because they already prescribed. DPRC moved for a partial reconsideration which was denied, hence the present petition. The issue which the Supreme Court held to resolve was whether the Court of Appeals was correct in amending the RTC decision, that is, by modifying MIAA's liability from the full amount of 9.5 million pesos to just 3.8 million pesos on the basis of the application of the 6-year prescriptive period governing the quasi-contract of solutio indebiti. The Supreme Court ruled in the negative, stating that in order to establish solutio indebiti, 2 conditions must concur. 1. Payment is made when there exists no binding relation between the payer, who has no duty to pay, and the person who received the payment. And 2. Payment is made through mistake and not through liberality or some other cause. Here, the essential requisites of solutio indebiti are not present. First, there exists a binding relation between DPRC and MIAA, that is, the lease contract. Hence, it cannot be said that the overpayment of monthly rentals was made when there existed no binding juridical tie or relation between payer DPRC and the person who received the payment, MIAA. Second, it cannot be said that DPRC's payments in monthly rentals in subsequently nullified resolution were made due to mistake on the part of DPRC. In solutio indebiti, undue payment must have been made by reason of either an essential mistake of fact or a mistake in the construction or application of a doubtful or difficult question of law. Mistake entails an error, misconception, or misunderstanding. Here, there was no mistake. DPRC deliberately made the payments in accordance to the nullified resolution, although under protest. Without any judicial declaration of the nullity of the resolution at the time, DPRC has no alternative but to make the subject payments, though again, under protest. Therefore, it is not correct to say that the subject payments made by DPRC were made by mistake or inadvertence. With the absence of the two essential requisites of solutio indebiti, DPRC's cause of action is not based on quasi-contract of solutio indebiti, but on contract of lease. Since the basis of DPRC's cause of action is a contract, its prescriptive period is 10 years, instead of the 6-year prescriptive period for quasi-contracts. Aside from erroneously applying the 6-year prescriptive period for quasi-contracts, the Court of Appeals also erred in stating that the applicable prescriptive period is reckoned from the date of DPRC's first overpayment. It should be reckoned at the time the assailed resolution was nullified in 2004, as it is the date when DPRC's right of action accrued. Furthermore, Article 1155 of the Civil Code provides that the prescription of action is interrupted when a written extrajudicial demand is made. So when DPRC made an extrajudicial demand for overpayments from MIAA, not only was the prescriptive period to file an action suspended, jurisprudence holds that the interruption of prescriptive period by written extrajudicial demand means that the said period would commence anew from the receipt of the demand. Written extrajudicial demand wipes out the period that has already elapsed and starts anew the prescriptive period. Hence, when DPRC made its written extrajudicial demand in 2006, it actually had until 2016 to file an action for the full recovery of the overpayment of monthly rentals. Accordingly, at the time DPRC filed a complaint for collection of sum of money in 2008, no claim for refund of overpaid monthly rentals had prescribed. That concludes our case for today. Thank you for listening. I hope you learned something new. And always remember, when you do a thing, do it well or not at all.